Good afternoon. Welcome to the regularly scheduled meeting of the Community Development and Regulatory Services for today, which is August 22nd. I've been joined by my colleagues, Councilmember Cano and Reich. We do not yet have quorum, so I apologize for that. And as soon as we have quorum, we will begin the meeting. Thank you for being here on time. I've been joined by council members Warsame, Reich, Fry, and Kano, which is a quorum of our committee. We will begin with the consent agenda, which are items 8 through 14. They include our partnership applications with the National Endowment for Arts for the Our Town program with Juxtaposition Arts and the West Bank Business Association. Item 9 is the regular liquor business and gambling licenses. Item 10 is a land sale for the Minnehaha Apartments, which is a MPHA project in the 12th Ward. Item 11 is a contract amendment with Everybody In for the Regional Racial Equity Project. Item 12 is a lease at the Upper Harbor Terminal. Item 13, Council Member Warsame will comment on. This has to do with a cooperative public market. Item 14 is accepting grants from DEED through their tax-based revitalization account. Item 15 is accepting Met Council Livable Communities grants. And item 16 is setting a public hearing. With that, I will call on Councilmember Warsame on item number 13.
Thank you, Madam Chair. And this is basically a study to look at the proposal for a cooperative public market at 2600 Minnehaha in Ward 2. And we're very excited about this. The community has been, the East African community, the Somali and Oromo community have been asking for ownership of a market. As you are aware, the structures in place right now have caused a great deal of hardship for both the community as well as the neighbors in Phillips and in Whittier. And the aim of this is to give success to startup immigrant-owned businesses in our city in order to eliminate disparities and to ensure that community assets are preserved and strengthened, as well as to increase the tax base. So I'm very excited about this, and I thank you for the work that you've done on this and all your support. Thank you.
Councilmember Fry.
Thank you, Madam Chair. I'd like to thank both staff as well as Councilmember Abdi Warsame for his leadership on this project. This is no small endeavor when you're talking about issuing off a city parcel, creating ownership within the Somali community for the long haul, and also, I guess, helping entrepreneurs really run with some tremendous ideas. I think this is a project that is ripe. It's a project that I'm very excited about on behalf of the Somali community.
Further comments or questions on the consent agenda? Seeing none, I'll move the consent agenda. All in favor signify by saying aye. Aye. Any opposed? Those items are approved. We'll then move back to our public hearing agenda, starting with item number 1, which is the U.S. Department of Housing and Urban Development's Consolidated Annual Performance and Evaluation Report. Matt, welcome.
Madam Chair and members of the committee, on August 29th, we will be submitting to HUD the annual report on how we use our HUD entitlement funds from that department for housing and community development initiatives in the city for the program year of 2016. As part of that process, there's a 15-day public comment period on that report, on the draft report, as well as this public hearing, and we'd ask that you'd open the public hearing, and we'll include any comments we received either at this hearing or during the comment period to be included in that report.
Are there any questions for Mr. Bauer on item number 1? Seeing none, thank you for your report. We'll open the public hearing on item number 1, which is a public comment on the HUD Consolidated Annual Performance and Evaluation Report. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Fry.
Thank you, Madam Chair. I move approval of this item.
Approval of item number 1 has been moved. Further comments or questions? Seeing none, all in favor signify by saying aye. Aye. Any opposed? That item is approved. We'll move then on to our land sale agenda, starting with item number 2. Mr. Ramadan, welcome.
Madam Chair, Members of the committee, we have our first item is 1800 26th Avenue North, the sale through Minneapolis Homes, policies for the program established by the City Council on December 11, 2015. The staff recommends the sale of 1800 26th Avenue North to Anissa Keys for its appraised value of $2,800, subject to conditions. Additionally, we are pleased to recommend awarding up to $20,000 to Anissa Keys as the first recipient of the Minneapolis Homes Program's buyer incentive funds. 1800 26th Avenue North was acquired on December 28, 2007 from a private owner for $190,000. Staff has continually marketed this property to a listserv of now over 1,700 people. This was the only application received. The property size or lot size is 80 by 127, or approximately 10,153 square feet. The purchaser intends to invest $240,000 to build a 4-bedroom, 2.5-bath, single-family home to live in as the owner occupant. CPED's construction management staff reviewed the scope of work and estimates submitted by the applicant's builder and confirmed that they are sufficient to meet the minimum construction standards for the program. Notification was provided to the Jordan neighborhood on June 21st, 2007. We have here in attendance today Anissa Keys, the applicant, Ben Akigbe, who is the builder of Bonneau's Construction, and actually the builder of our first 4 Green Homes North homes. I don't see Deb Wagner, who was from the Jordan neighborhood, here today, but are there any questions?
Are there any questions for Mr. Ramadan on item number 2? Seeing none, thank you for your report. We'll open up the public hearing on a land sale at 1800 26th Avenue North. Is there anyone here to speak to this issue? Is Ms. Keys here? She is. Hi, do you want to come up? Hi.
Hi.
Congratulations
Thank
to
you.
It's really an amazing thing that you're going to be able to build a house on the site. Maybe you could just tell us a little bit about what you're thinking.
Yeah, so I'm a resident, long-term resident in North Minneapolis, raised on 10th and Oliver. I currently live on 32nd and 6th Street, North Minneapolis, with my 4 children. Single parent, I'm a business owner, and I have partnerships in North Minneapolis, and I'm just really invested in the community. And so I'm excited to build in my community.
We're really happy for you. And thank you very much for being here. Is there anyone else here who would like to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Kano.
Thank you, Madam Chair. I would like to move the staff recommendation forward.
Item number 2 has been moved for approval. Further comments or questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Thank you very much for your investment in the city. We'll move on to item number 2. Mr. Ramadan.
Madam Chair, committee members, our next item is 3019 Logan Avenue North, and that, again, through the sale of Minneapolis Homes, policies of the program established by the City Council on December 11, 2015. The staff recommends the sale of 3019 Logan Avenue North to SP Homes LLC for its appraised value of $20,000, subject to conditions. 3019 Logan Avenue North was acquired on May 19, 2016 from Hennepin County as tax forfeited land for $20,000. Staff marketed this property twice since acquiring it without any offers. 2 final open houses were held on April 2017 with the notification sent to a listserv of now over 1,700 people. This is the only application that we have received. The property was constructed in 1924 as a 1,560 square foot, 2-bedroom, 1-bath, single-family house. The purchaser intends to invest $79,350 to rehabilitate 3019 Logan Avenue North as a 2-bedroom, 1-bath, single-family home to sell without restrictions. CPED's construction management staff has reviewed the scope of work and estimates submitted by the applicant and confirmed they are sufficient to meet the minimum rehabilitation standards of the program. Notification was provided to the Jordan neighborhood on June 21st, 2017. The builder, Mr. Ganesh Ram, was intended to be here today. Unfortunately, he had a family emergency, had to go to the hospital this morning, so he wasn't able to be here. Are there any questions?
Are there any questions for Mr. Ramadan on item number 3? Seeing none, thank you for your report. We'll open the public hearing on item number 3, which is a land sale at 3019 Logan Avenue North. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Frye.
Thank you, Madam Chair. I move approval of this item.
Approval of item number 3 has been moved. Further comments and questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll move on to item number 4. Mr. Ramadan.
Madam Chair, council members, item number 4. the sale of 3125 Bloomington Avenue South to Robert Arndt for its appraised value of $20,100 subject to conditions. 3125 Bloomington Avenue was acquired on October 23rd, 2015 from Hennepin County as tax forfeited land for $1. Staff has continued to market this property since acquiring it. On June 21st, 2016, the City Council approved the sale of 3125 Bloomington Avenue South to Tim Riesgard for $20,100, subject to conditions. However, that sale was canceled. Staff received another offer from Robert Arndt on January 9, 2017. The lot size is approximately 42 by 122, or approximately 5,143 square feet. The purchaser intends to invest $216,173 to build 1,968 finished square feet, 2-bedroom, 2.5-bath, single-family home to live in as the owner-occupant. Again, CPED's construction management staff has reviewed the applicant's proposal and found that it does meet minimum construction standards. Notification was provided to the Powderhorn Park neighborhood on February 2nd, 2017, and the staff received notification on June 2nd, 2017, in full support of this proposal. Bobby Arndt is actually here today. Are there any questions?
Are there any questions for Mr. Ramadan on item number 4? Seeing none, thank you for your report. We'll
Okay.
open up the public hearing on item number 4, which is a land sale at 3125 Bloomington Avenue South. Is there anyone here to speak to this issue? Mr. Arndt, come on up. Let me first congratulate you on building a home in the city, and thank you for doing that.
Thank you very much.
Would you like to say something about what you're doing?
Sure. So my home will focus on green building techniques. A lot of what I'll do, or a lot of the interior work I'll do myself. So like all the floors I'm milling by myself, all the trim work. It's all from local trees. What else? Other than that, I'm just excited to be part of the Powderhorn community.
Well, great, and thank you for being here today.
Thank you.
Is there anyone else here to speak to this issue? Seeing none, I'll close the public hearing. Councilmember Kano.
Thank you, Madam Chair, and I look forward to being your neighbor. I also live in Powderhorn. I would like to move this forward.
Item number 4 has been moved for approval. Further comments or questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Good luck to you. We'll then move on to our business and licensing public hearings, starting with item number 5. Mr. Wilson.
Thank you, Madam Chair. We have an application by Lannister LLC doing business as The Cove for an on-sale wine and strong beer license, Class E, with a private outdoor patio. They are currently located at 1320 5th Street Southeast, and they have operated a restaurant there without wine and beer since November of 2016. This is in the Marcy Homes neighborhood in Ward 3. They have interior seating for 25 guests and exterior seating on their patio for 18 persons. Generally open from 11 a.m. to 9 p.m. The two owners are Lee and Lakna Sathong are the owners. And the Cove will serve a variety of fast casual Asian dishes. A public hearing is required for this application, and we did notify all property owners and residents within 600 feet of this address about today's public hearing. We also notified directly the Marcy Homes Neighborhood Association and the Northeast Minneapolis River District. We received no responses from our mailing about today's public hearing for or against the application. We find that it meets all of our requirements, and staff's recommendation is that the application be approved.
Are there any questions for Mr. Wilson on item number 5? Seeing none, we'll open the public hearing on item number 5, which is for the Cove for a on-sale wine and strong beer Class E license. Is there anyone here to speak to this issue? Is there anyone from the Cove here? Come on up. Thank you for being here today. Just a little advertisement.
Sure. Well, thank you for having us, and thank you for bringing this to the attention. We're very excited, to be able to offer local beers to the restaurant, which will hopefully attract more guests and be competitive within our market.
Well, thank you for being here today and for your investment in the city. Is there anyone else here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Fry.
Thank you, Madam Chair. Really excited to have you. Thank you for your investment, and happily move approval of this item.
Approval of item number 5 has been moved. All in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Our last public hearing on the License and Consumer Services agenda is item number 6. Mr. Wilson.
Madam Chair, I believe Lori Johnson from the Finance Department will be giving today's presentation.
Oh, great.
Thank you.
Ms. Johnson, welcome.
Thank you. Glad to be here, Madam Chair and committee members. Lori Johnson, Deputy CFO, here to present the fees for 2018 as required. We must hold a public hearing prior to September 1 on our business license fees. We are proposing no increase for 2018. Notice was given to license holders. We received one positive comment back regarding the fees in this case. And also for your information, we are in the midst of a fee study. We have begun that, have considerable work underway, but have a ways to go. We anticipate having that back to you prior to next year's fee setting. And with that, we recommend approval of the fees as presented.
Are there any questions for staff on item number 6? Seeing none, thank you for your report.
Thank
We'll
you.
open the public hearing on the 2018 license fee schedule. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, I'll close the public hearing and move approval myself, since it does not involve a fee increase. Further comments or questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. The last item on our agenda today is a quasi-judicial public hearing chaired by the Vice Chair of the committee, Councilmember Fry.
We have one item on the quasi-judicial hearing agenda for today is item number 7, which is a business license for Julia Wang and Orchid Massage Spa, doing business as Orchid Massage Spa at 4933 34th Avenue South. Here to present is Mr. Fussy.
Thank you, Mr. Chair. I can represent the city with regard to this matter. Initially, I do know that a translator was brought in at the evidentiary hearing in this matter, although I don't believe she was utilized, and a translator is available today for the licensee, and I'd like to inquire of counsel for the licensee if they want to utilize the services of a translator. Okay.
I'm the interpreter for Julia.
Okay. Do you want her to sit next to your client, or how would you like to proceed?
Yes.
Thank you, Mr. Chair and committee members. This matter involves the business license held by Orchid Massage Spa and its owner, Julia Wang, for a massage parlor located at 4933 34th Avenue South in Ward 12. Specifically, it concerns the recommendation of business licensing staff to deny renewal of the massage and bodywork license held by the business. An evidentiary hearing was held in this matter on May 30th in front of Minneapolis hearing officer Michael Sint, and on June 29th, he issued his detailed findings of fact, conclusions of law, and licensing recommendation, which is now in front of this committee. I should also note, as I believe you're aware, that counsel for the licensee submitted objections and some other documents regarding his client's position recently, and they were also distributed and provided to the committee members. In the hearing officer's recommendation, he found that good cause exists to deny the renewal of the business license. The hearing officer's license denial recommendation was predicated on several ordinance violations and other findings of inadequate and substandard business management practices, leading him to agree with staff that renewal of the license would not serve the public interest. The hearing officer found violations and deficiencies in 5 general areas of the business operation. First, the licensee was in plain violation of the building code by failing to repair its boarded up, large front plate glass window for several months after being ordered to do so, even after falsely claiming to city staff that the repairs had been made. Applicable Minneapolis code, as cited by the hearing officer in his findings, requires business licensees to maintain their businesses in compliance with all laws and codes, specifically including the building code. Additionally, false representations made by the licensee regarding the completion of the work violate multiple business license management responsibilities found in the ordinance. Second, The licensee violated applicable ordinance requirements by not having required staff employment records immediately available to license inspectors during the course of their site inspection, or even present on site. Counsel for the licensee, in his submissions, has argued that this requirement is legally invalid. However, as a closely regulated industry, the requirement is legally supportable and valid and an important regulatory tool.
Mr. Fussy, what's the requirement again? If you could repeat that.
That a massage parlor, a massage and bodywork licensed establishment must keep on premises records of all of their employees in order to prove that they're of age and qualified to work. Thirdly, during the on-site inspection of the business, the licensee incredulously claims to have left in charge of the facility a woman she had only met that day so that she could go shopping and dine at a restaurant. The licensee testified that she did not have any identification for the woman, could not recall her name, had only met her that morning to interview her for a masseuse position, and had not completed any background check on her. Despite all of this, the licensee's own testimony at hearing indicated that she nonetheless decided to grant this unidentified person complete dominion over the business while she was away. The licensee was unable to say whether the woman was an employee or not at the time. The unidentified individual who was left in charge told the inspectors that she was the only one present at the business, a claim that proved to be false when a masseuse and a customer were confirmed to be on site before retreating into a back massage room. Therefore, neither the licensee nor a proper manager was present at the facility during this time, leading to a conclusion that the business was not being run in a responsible or reasonable manner, or that the licensee was being intentionally evasive in her explanations. Fourth, the record establishes that the licensee has entered into contracts with its masseuses, who are categorized as independent contractors, which attempt to circumvent her ordinance-imposed liability for the actions of her staff. In fact, the licensee directly testified and conceded that masseuses working for her have previously committed illegal sexual acts during massages and that they might continue to do so, in clear violation of cited ordinance provisions and in contravention of the duty of licensing staff and this council to only grant the privilege of business licensure to entities that will operate lawfully. Fifth, the hearing officer also found that the totality of the operational observations derived from the investigation into the establishment constitutes good cause for license denial. This was based on the extensive expertise and professional knowledge of commercial sex and trafficking-related enforcement by the business licensing staff that were assigned to this matter. It was also based on the observed conditions in the establishment involving on-site food, cooking equipment, clothing, and bedding provided for the workers on a scale far beyond what would be expected in a legitimate massage establishment. The utilization of advertising websites directly correlated with illicit activities such as Backpage, which was the exclusive advertising venue for the business at the time of the inspections. The sexually provocative content of those advertisements, the evasive behavior of customers parking and approaching the business, and the substandard, unkempt, and shoddy condition of the establishment in general. Recent case law from the Minnesota Court of Appeals involving other massage parlors in Minneapolis supports the use of many of these types of factors as part of a city's broad licensing discretion when making licensure determinations. Finally, it is important to note that the hearing officer specifically found that the licensee's assertions that city staff were hostile to minority-owned businesses and that staff's recommendations constituted veiled racism to be entirely unfounded. Conversely, the hearing officer specifically found that the testimony of business licensed staff was credible and fact-based, and that the licensee's own testimony largely supported the conclusions that were ultimately drawn. Therefore, the Business Licensing Division requests that this committee adopt the report and recommendation of the hearing officer in its entirety and deny the license renewal application before you. Thank you.
Thank you, Mr. Fussy. First, I just want to be certain that all items were translated and there's a full understanding of what Mr. Fussy just said. The key points. Okay. I understand. Just to be sure that everything was heard and understood, may I ask if there were any additional questions, and we can certainly have Mr. Fussy repeat. Okay. Are there any questions by council members to Mr. Fussy at this point in time? Okay, seeing none, I will open the hearing here and read an introductory statement. This is a quasi-judicial business license hearing for which this committee is limited by law to hearing argument from the licensee or the licensee's representative, but is prohibited from considering any further evidence or taking any further testimony. So this means that the parties are required to limit their comments to arguments specifically addressing the evidence or testimony introduced before the administrative law judge, which is part of the record that is before us. So to repeat, you may not offer and we may not consider any new or additional evidence. The committee has reviewed the report and recommendation of the administrative law judge, and any written exceptions filed by the parties and has been provided with the official record of the administrative hearing. So again, based solely on this record, we will either affirm, modify, or reverse the recommendation from the ALJ. So at this point in time, we can hear for either the licensee and or the licensee's representative. If you will come forward, please, and state your name and address for the record, sir.
Your Honor, Randall Teig, 604 North Lilac Drive, Golden Valley, Minnesota.
I'm sorry, your name again?
What?
Your name again?
Randall Teig.
Randall Teig. Thank you.
And
Teig.
I have provided the body with objections to the order, and I'd like to take them in the order presented by Mr. Fussy. First, with respect to the window in question. The testimony before the hearing officer was that in the November inspection, they found a boarded up window. The licensee testified that she went to the landlord, got the existing board replaced by a sheet metal painted the same color as the building. That proved unacceptable to the city. She turned it into the insurance carrier, left it to the insurance carrier. The insurance carrier repaired the window by March when the license application was made. So by the time the license application was made, the window had been fully repaired. The ordinances in question say you cannot make a false representation in the course of an application for a license. Even assuming what my client told the city back in November, it was false. It wasn't in connection with the application for a license. No city ordinance was violated, and by the time a new license application was submitted, the window had been fully repaired. With respect to the parking lot, or the parking that customers parked a block away, her massages usually last an hour or more, and there's a 1 hour limit on parking in the street. It is not unusual that one would not risk a parking ticket to get a massage. I believe the next question is the maintenance of employment records. The fact is she was in the middle of an interview for a prospective masseuse. She testified that she had to go to IKEA to get some materials, and was going to go to lunch and invited this new prospective employee to go. The new prospective employee says, "You just don't go. I can stay here and watch things." And it may not have been the wisest business decision to make, but it doesn't violate the ordinance. The
Mr.
ordinance
Tighe, are you denying at this point that she previously stated that she had just met this individual that day?
That's correct. She met the individual that day. The individual responded.
So you're not denying that she met this individual
she
that day?
met the individual that day, but she wasn't an employee and didn't have to, and maintenance of records on her were not required under the terms of the ordinance. In fact, she has chased her down and has provided a declaration. We know exactly who she is. We know she's not underage. She's licensed to provide nail services in the state of New York. And what happened is these officers simply scared her away. She wasn't able to identify her because she blocked phone calls and was scared from participating, given the fact that she was subjected to interrogation in a language she didn't understand. So,
is there
as soon as this,
Mr. Tighe, is there a reason given for why you would put someone in charge of your business, of one's livelihood, that you had only met that day?
Well, she invited her to come to lunch with her, and she insisted she could stay and watch the business while she was away.
So there's no reason given.
I mean, above and beyond that, there wasn't any reason. But again, she's only required to maintain records of employees, and this person was not an employee, hadn't been hired, never was hired. She subsequently came in and provided all the required records to the city after this incident.
So, I mean, I just got to go back to this. The law requires that you have records of all employees on the premises. So either one, the law was broken very clearly, or two, it appears that this story doesn't make sense. I hope you can kind of work with me on this. It doesn't make sense that you would let someone who you just met on that day run your entire business while you go to lunch.
That was not a wise decision. I'll have to admit that. But it doesn't violate the ordinance unless she was an employee, and she wasn't an employee. Now, with respect to advertising on back pages, first of all, the finding that was her exclusive method of advertising is absolutely unsupported by the record. She advertised on city pages, she advertised on Google, she advertised on Facebook and Twitter, all of which was testified to, and the city employee said, I didn't check out any advertising except back pages. Secondly, back pages is clearly not clearly doesn't relate exclusively to illegal activity. In fact, the United States Court of Appeals for the Seventh Circuit enjoined the Cook County Sheriff from attempting to intimidate credit card companies from supporting back pages, specifically finding that back pages is not exclusively a site dedicated to illegal activity. I think what is absolutely the most absurd finding at all by the hearing officer is conclusion number 9, relating to the independent contractor agreement signed by everyone who works there. And what that agreement essentially says is, first, you're prohibited from engaging in illegal activity. Secondly, if you do it, you're on your own. It means We won't bail you out of jail. We won't provide you an attorney. We won't pay your fines. You are on your own. To suggest that this somehow countenances illegal activity is utter nonsense. What if the agreement said exactly the opposite? What if the agreement said, if you get arrested for illegal activity, we'll bail you out of jail, we'll hire you a lawyer, and we'll pay your fines? Mr. Fussy would be screaming bloody murder that we were subsidizing prostitution. The agreement she had is exactly what somebody who doesn't countenance prostitution on the premises would do. And yes, she testified prostitution might happen. That's a statement that every single licensee of a massage establishment could make. It is physically impossible to guarantee that prostitution won't take place on any premises, massage or not. And I would suggest to you that there's not a member of this committee who couldn't guarantee that prostitution won't be solicited someday in Minneapolis City Hall. For her to say that prostitution might occur, even though she prohibits it, even though she says you're going to be fired right away if you do it, even if she says we'll give you no support if you get arrested for it, there is nothing any business owner could say that would go beyond that. And this doesn't in the slightest way suggest that prostitution won't be considered. Now, there was a reference made to a website that reviews houses of prostitution. Introduced into evidence was an ad from that website reviewing massage parlors, and this massage parlor was specifically labeled as non-erotic. And if you look at the reviews, the reviews that are cited there, they clearly say you don't get any sexual services at this site. Now, a remark was made about there being no evidence that this decision by the city was racially motivated. I would suggest to you that the evidence the city introduced says exactly the opposite. One of the things the city introduced was a magazine article about how young girls are trafficked into prostitution at Chinese at Chinese massage parlors or at Asian massage parlors. There's absolutely no reason to introduce that into evidence when there's no evidence relating that to this establishment. And the only possible reason to introduce that evidence is to play the race card and say, because this is an Asian massage establishment, just like the ones in this article that had nothing to do with this location. No reason to introduce that other than to suggest to the hearing officer that because this is an establishment operated by somebody of Chinese ancestry, that therefore it is operating in human trafficking. The last thing I would mention is the Young Green case, which went to the Court of Appeals. The Young Green case is distinguishable for one very obvious reason. In that case, somebody was arrested at the massage establishment for engaging in an act of prostitution. No such evidence is present here, and in fact, the city's officer testified on cross-examination. She had absolutely no direct evidence that a single illegal act ever occurred here. So I think the hearing officer's decisions are absolutely unsupported by the evidence. And this body should reject the conclusions of the hearing officer and renew my client's license.
Thank you, Mr. Teague. I'm assuming that was the full presentation on behalf of the licensee. Is there anyone else that would like to speak on that topic? If not, that's fine. Okay.
I'm here. I think I'm not only stand for myself.
Can you please just state your name and address for the record? Thank you.
Julia Wang. My address,
Yes, please.
residential address, 12133 7th Street, Northeast, Berlin, Minnesota 55434.
Thank you.
As an individual small business owner, I mean, I was really scared because they were trying to shut me down where I didn't do anything wrong. What made me brave is like I feel I have to stand up to face the public, to speak out, because I want you to give me a fair judgment, not only because I'm Asian, I'm Chinese, because there's no any evidence says I'm engaged with human trafficking or prostitution in my business. I do have a messy back room, and it's not bad. It's a 2 broken massage table. It's old, used massage table. I put there because massage is heavy duty work. Sometimes that we get really tired, lay on the massage table to relax. It's going to give us a back a release. That's one thing I want to mention. It's not bad. It's too old massage table. Second, I want to talking about our eating habit as Chinese. Okay, we like to eat warm food. We never enjoy cold lunch like a sandwich and Coca-Cola or something. We like to eat warm food. We like eat a warm rice with some vegetable. So I provide a rice cooker in my massage parlor back room. That for my independent contract, sometimes they want cooking just the rice, some warm rice. That's what I provide for them. But that not necessarily means I have people stay overnight in my massage parlor. Third of all, I want talking about the English, talking habit. I come to the United States 2003, and now I'm a citizen. But if you ask me where you're coming from, I will say I come from China. So at the inspection that day, the girl, when they ask the young girls, the girl says, where you coming from? She states she's from China. I think that's absolutely reasonable because even today you ask me, I will tell you I'm from China, okay? But I'm already citizen. Third of all, I also want to say, she already tell the inspector that my English is bad. I don't understand why they cannot put an interpreter online to talk to them. So everything will be much clearer. So they are not thinking this person is like underage or it's like because she totally don't understand. She already said my English is bad. You know, how could you get any result that because someone cannot speak good English? I didn't leave that store like 100% uncontrolled by her. It's because it's not, our business is not too busy. So we have a customer come in and office, not like every day we have a lot of customers. Sometimes like one day we only got 1 or 2 customers coming. So I didn't think that much that I leave her in the store will cause any problem. Yeah, I invited her to join me for lunch. She said she's not hungry. She said, you go. If there's customer coming, I will tell them to wait for you. And that's the fact, that's customer coming. She said, the masseuse is not here. Will you be able to wait in the rooms? And the customer said, okay. And she lead him to the rooms and let him just waiting inside the room. I believe that she's the only one there where I'm out. I don't know there's another female or whatever. It might be another couple massage. A couple. It might be another couple customer who come in to searching for massage services. Because that day I should have one more staff working who is my true currently working with, who working at that time, and she's still working for me even till today. So she working for me for more than a year now. She just take a day off because she said she feels really tired. She's sick, So she take a day off, and I'm just out to IKEA. That's what happened. But it's not. All the proof is not pointed to me that I'm running illegal business. I can't take that.
Is this particular individual an employee of yours that you're talking about?
I don't catch your question.
Is the individual is the person that you're talking about right now, is she an employee or is she an independent contractor?
You're talking for that day the inspector come in, meet that girl?
I'm talking about the person who you've said who has been with you for quite some time now.
Yes, she was, that girl was sick at the day when inspector come in. She was sick. She's supposed to work. She and me supposed to work together. She is sick. At then I was thinking, no one could work in 7 days. So I was thinking, hire a second person so we could take turn to get some days off. That's why I'm start to interview persons. And then this girl, her husband drove her in around 10 a.m. and we talk. And then I tested her massage skill, which is okay. So we are just in consideration. For me, I will consider if she, I'm trying to hire her, and she's also concerned so we're just in the processing. We nothing is confirmed. That's why I didn't have all her, all her ID and information. But my other worker, who is two Minneapolis lady, I provided their driver's license. They're both Minnesota resident, and their school staff. They are all professional trade, like they have all more than 500 hours training down professional massage school. So those two persons was my employee. But this young girl, she's not young, she's 35 years old. She's younger than me though. Yeah, this lady, she's not my employee at that time. And she got really scared because a police officer come in and two lady from the license center come in. She don't know what's going on. She's really scared.
Okay. Thank you. Anything further to add?
Let me say my lawyer have something to say.
Please. Yeah, if you would just state your name and your address, and if you'd please be brief on the
very
primary
brief.
points, as we've already heard from one representative.
Good afternoon. My name is Ryan Case, downtown St. Paul, Minnesota. I was the trial counsel for Ms. Wang, and I will be handling any further appeals for Ms. Wang, which there will be, because I want to be very blunt with this committee. I have practiced law for 15 years. I know you are shutting down a business because of a broken window. That's it. There was never any sexual services in this place. You have no evidence of it. None. Zero. Zilch. You want to shut down a Chinese-owned business because of a broken window. I live in St. Paul, and I'm watching this mayor's race with a lot of curiosity because every one of you talks about diversity and how you want that for this city. But as soon as a couple neighbors complain about a Chinese massage parlor, you forget what actual diversity means. Let me be very clear. There was never any sexual trafficking in this business. What you heard, and I hope you got the transcript of the hearing, because it's clear if you read the transcript, this city did not prove anything. You want to shut down a business for a broken window. And I believe you want to shut down that business for a broken window because it's owned by a Chinese woman. Thank you.
Thank you for your testimony. Mr. Fussy, what was the testimony that took place at the administrative law judge hearing regarding the possibility of sexual activity happening during the massages?
Well, Mr. Chair and committee members, as referenced in the record and in the findings, the license inspectors that were assigned to this, in particular, License Inspector Beth Roberts, who's now employed with the state Human Trafficking Task Force, has extensive expertise in commercial sex, in the commercial sex enforcement and regulation area. And based on her expertise and experience and a lot of the factors that she saw here, and specifically the admission, the testimonial admission of the licensee that passed the Legal Sex Acts had taken place with... What was the testimonial admission? The licensee testified on direct testimony that masseuses in her employ had previously committed illegal sex acts for greater tips, and she said that they might in the future.
Further questions?
Mr. Chair, Mr. Fussy, I'm just wondering, given that, you know, we kind of operate under the basis that business license is not a right, but a privilege, I'm wondering, under what authority do we have to revoke any license?
Well, we have extensive and broad, or you have extensive and broad authority in the issuance and considerations of license applications and license matters, and specifically that includes an examination of good cause, which is included within our ordinance and which has been recognized by Minnesota courts, and it includes an examination of the public interest. And I think that the record in this matter cites to numerous ordinances which were violated. I certainly concede that this is not a case in which we have an undercover prostitution sting or something along those lines, but I would also submit that that is not a prerequisite for a license denial or a license non-renewal, and coupled with the strong evidence of in the testimonial admissions and the other ordinance violations that have occurred here, it's the business license department's recommendation that continued operation of this business would not be in the public interest, and the hearing officer agreed with that recommendation, and that is what is before you.
Mr. Chair, Mr. Fussy, what evidence is there in the record with regard to the threat by the applicant's attorney that the city is discriminating against this applicant because of her nationality?
Mr. Chair and committee members, it certainly has been a theme of their defense in this matter. I'm unaware of any evidence in examining this matter and in dealing with my clients in the business licensing division that would lead me to conclude that that's justified. And in fact, the hearing officer went out of his way to make a specific finding that it was not.
Thank you, Mr. Chair.
So, Mr. Fussy, and please correct me if I'm wrong. So we have an admission that sexual activity has happened in the past. We have an admission that it might happen in the future, and there seems to be a desire to eliminate any responsibility because these individuals are independent contractors.
Mr. Chair and committee members, and yes, that's how I would view that, and I think how the hearing officer viewed it is that there is a requirement under the Minneapolis ordinance that licensees of these establishments are both directly and vicariously liable for the actions of their employees and independent contractors, any staff members. And so by operation of that ordinance, I think it is implicated, and I think that that provides an additional component of good cause to deny this license.
And that vicarious liability applies not only to activity that would result in a criminal charge, but also activity that could result in a business license revocation.
That's correct.
Okay. Yeah, I'm going to move approval of the staff recommendation on this one to revoke the license. Do my colleagues have any discussion on this item? Seeing none, all those in approval, please say aye.
Aye.
Aye. All those opposed say no, and that item passes.
We have completed the quasi-judicial public hearing portion of our agenda, as well as the public hearing and consent agenda. Seeing no further business before us, we are adjourned.